Good afternoon. My name is Irene Parker. I am with Timeshare and Resort Developer Accountability, a 501c4 nonprofit. Today is Timeshare Solution or Surrender, episode 82. And that's pretty hard to believe. And today we have an honored guest. I introduce attorney Connor Spanny in Washington State. And Connor is the fifth attorney to be on our show, including our producer, Nick Palavita, who is a pension attorney and learning about the wonders of timeshare. I've also invited two people who are disputing their timeshare transaction. First, we have Mary, and we also have Aku. And both of them are residents of the East Coast. So this timeshare legalese and arbitration can get pretty complicated. So I've asked Aku and Mary to be with me today. I'm going to be taking some notes and to help me understand some of I have 9 questions here, and I just remembered the 10th question, which is, I think, the one that people ask the most, is should I, if I take legal action, whether through arbitration, will I have to keep making my loan payments? But before we do that, and I'm going to just give a brief background about Aku and Mary, and we're going to hear from Connor, and because I don't want to shortchange that lecture on arbitration. But I'm hoping we have time at the end to talk about your two particular situations that I feel are hopeless for. We've had people try to overcome credit card debt. It's not easy. 3 or 4 people that went ahead, and a couple ended up in court, and they settled with the credit card company for 50%, around 50% of the due. So Aku, you're from Africa, correct?
Yes, West Africa.
What part of Africa?
West. I'm from West Togo.
Okay, so Aku has never financed anything in her life, and she purchased a Wyndham timeshare, and they said it was going to be 17,000, and she divided 17,000 by 210 loan payments, and it was a reasonable amount of money. And I said, well, have you ever bought a house? No. And so you're not born with this information, but even if you buy your house and you see what it's amortized out to be, so you were unaware that they had opened an $8,000 credit card, right?
Yes.
And the interest rate is 25%?
Yeah, it's 19%, I think, something like that, around 19-20.
Okay, and we have Mary, who's in a worse situation where she was not aware, and we hear this all the time. Credit cards pop out like toasters that they open for you. And so Mary said that she was unaware, just like you, that they had opened a credit card, and her sister was with her, and she says, well, I can probably get a loan. I have good credit score. Well, just that $17,000 charge caused Mary's credit card to go down about 100 points. And if that's not bad enough, she retained an exit company that charged her $4,000 and said, we can help you with your Wyndham contract, but we can't help you right now with the credit card. We'll do that later for more money. So Connor, just keep that in the back of your head, and hopefully we'll have time to see if an attorney can help either of these poor people that were, just had to be financially devastated because they bought a product that's supposed to bring joy and fun and relaxation to their families. So, Connor, tell us how long you've been practicing law. I know from your website you're not just a timeshare lawyer. You've practiced in several areas, and what led you to timeshare, and then we'll jump into arbitration.
Yes, absolutely. Irene, thank you so much for having me on the show today. I'm excited to be here. I think the work that you're doing is absolutely wonderful, and so I'm happy to be a part of it. I've been practicing law. I think I'm going on my 7th year, 6 or 7 years. I just happened to come right out of law school and work for a law firm that's sole purpose was to help distressed timeshare owners find a resolution to their situations. And while I was at that law firm, there's many lawyers, as I've come to learn, that don't want to pursue what I would consider meaningful justice for consumers like Mary and Aku. There are many lawyers who simply want to provide an exit and say, I'm going to find a way for you to cancel your timeshare. And that's kind of what the law firm that I was working for was doing. And I had reviewed so many of these contracts. I mean, I probably reviewed over 1,000 timeshare contracts while I was there because it was a volume business. We were representing a large number of consumers in kind of the most expeditious way possible and trying to get them out of their contracts quickly. But what I noticed was that there is an arbitration clause in basically every one of these timeshare contracts. And, I learned about consumer arbitration. A consumer arbitration is different than normal arbitration. I think that's one thing that's really important to understand right off the bat is that there are certain consumer rules. They're often referred to as the minimum standards for consumer arbitrations that are set and promulgated by the arbitration administrators. So the arbitration administrator is a company that hosts and helps facilitate the arbitration. It's a private company, and they have recognized that it's important to protect consumers and make sure that the contracts that consumers are signing do not include terms that are unfair to the consumer. And so by the way that they do that is they say to the companies, they say, you can only have our arbitration clause and only use us as an arbitration host if you agree to our minimum standards for consumers. So one of the big things is that if a consumer files an arbitration, the consumer's maximum financial responsibility to the arbitration administrator to conduct the arbitration is about $230 to $250. The rest of the cost of the arbitration is entirely borne by the business. And if you go all the way through the arbitration process, just the cost of conducting the arbitration is about $50,000 in my experience. Could be more, could be less. But that means that the business is solely responsible for this expense, which in all likelihood, in most situations, they will never be able to recover that, even if they win the arbitration. They're simply just responsible for the cost. It's the cost that they pay for using an arbitration clause. Also, consumer arbitration.
One question, but they will have to pay your fee.
So my fee is, are you talking about the timeshare developer or the consumer?
The consumer will pay for your fee. I'm assuming you would require a retainer.
Yeah, so the way that my compensation works is I try to be as accessible as I possibly can to the consumer. So I charge a relatively small retainer fee up front, and then I also charge a contingent fee. But my goal really, and the only way that this really makes economic sense for me to take these cases is if I win the case and there's an attorney fee shifting provision in one of the laws or one of the methods of recovery that we're alleging, which is usually the case under consumer protection statutes. So for example, in Washington State, we have what's called the Timeshare Act. It's RCW 64.36. It has a list of things that are illegal in timeshare sales presentations. One of the provisions says that if any misleading or false statement of material fact is made in the course of the timeshare sale, then that is a per se unfair and deceptive practice under a different act, which is called the Consumer Protection Act. So if a consumer prevails on a Consumer Protection Act claim, they're entitled to not only their actual damages and interest, they potentially get treble damages in the way of exemplary or punitive damages. So it's possible that they recover even more money than they actually spent. But hold on, let me just finish. So there's a mandatory award of attorney's fees for a consumer that prevails on a Consumer Protection Act claim. So to put that all together, if the timeshare developer violates the Timeshare Act, that constitutes a predicate act for the Consumer Protection Act, and thereby there's a mandatory award of attorney's fees, which reduces the cost to the consumer for my services. I no longer charge a contingent fee. I just take the attorney's fee and the flat fee, and they're entitled to everything else. So I'll just tell you as an example, I just had one of these cases go all the way through a final arbitration hearing. It was probably the most complex arbitration I've ever handled. There's 5 contracts entered into over the course of 20 years or so. And we were able to get all 5 of the contracts rescinded or canceled. We were able to get my clients $30,000 approximately of their actual damages and interest. There was 2 violations of the Consumer Protection Act, and they were awarded $25,000 per violation. And then on top of that, the timeshare company was ordered to pay my attorney's fees and costs of approximately $113,000. So that's what's possible under these consumer protection statutes. And that's my goal. I spend many, many hours on this. And the only way it makes economic sense for me to take these cases is if I win and I am awarded an attorney's fee award. And that is a risk that I am taking. And it's a risk I'm taking because I'm passionate about this work, but I also believe wholeheartedly that I can win. I should win basically every case that I take, because as we all know, the fraud is egregious, it's prevalent, and I can prove that, and I can prove it through the use of consumer arbitrations. And I've done that, and I intend on continuing to do that.
Okay, so my question is, how do you overcome the oral representation clause in which Mary and Aku agreed that they did not rely on anything a sales agent said, which attorney Mike Finn's been on the show before. Episode 11 was quoted in the New York Times as the license to lie clause. It's in other contracts, but it seems like it's overworked in timeshare. How do you prove? And it's not just, well, I didn't say that.
Sure. So first of all, it doesn't matter whether there's a clause in a contract that says that you're not relying on anything I'm saying. So again, I'm in Washington State. My office is in Gig Harbor, so I'll reference Washington law, but there are a lot of similar laws throughout the United States. But basically, the Washington State Timeshare Act says if there's any false or misleading statement of material fact made in the course of a timeshare sale or in the timeshare sale presentation, that itself is illegal. It's a violation of law, as I previously described, and it's a colorable action. It's a viable claim, and that's all you have to prove. It doesn't matter whether they have an oral representations clause. Those two things are essentially unrelated. It's still illegal to say anything that's false or misleading.
But are they going to believe the timeshare owner? What about the sales agent that says, I didn't say that?
Sure. So that's a great question. And in my experience, my clients are all very credible. So first of all, as we know, there are many, many, many victims of timeshare fraud. And they truly are victims, right? We know that is in fact the truth. So when we go to an arbitration hearing, we present our witnesses. So my primary witnesses, and the primary way that we prove our case is through the testimony of the consumer, who are my clients. It's usually a married couple. Sometimes it's even a family. It's the married couple and their kid or their kids that were all present during the sales presentation, and they tell their story. And then the sales agent, can get up and tell his side of the story. They can call the sales agent. Sometimes I even call the sales agent, because many times, during the course of the discovery process, we ask for all of the complaint history against each particular sales agent that was involved. And many times it's an extensive list of complaints of fraud by other consumers. Yes. And there's ways that we can introduce evidence in arbitration that are not necessarily available in court, but that can demonstrate that this is not out of character for this sales agent in particular, or for the company as a whole. And so the job of the arbitrator is to determine at the hearing who's credible. And oftentimes I'll have like a married couple who's 75 years old, who's, they feel that they've been misled or deceived or defrauded. And they tell their story. And oftentimes, actually, I think all the time, in my experience, that's been extremely credible. And then the timeshare sales agent can show up and tell their story. And the burden of proof is on the plaintiff or the claimant in an arbitration, but it's a preponderance of the evidence standard, which just means, is it more likely than not? Does 51% of the evidence suggest that what the claimants are saying is true? And in my experience, the arbitrator has recognized that my clients, the consumers, are in fact credible in telling the truth. And that's all that's necessary. Now, there are other ways that we can try to admit different evidence. It just depends on a case-by-case basis. For example, in the way of timeshare sales agents, like their complaint history. I'm not going to name names, but most of the major timeshare developers have an internal system for logging complaints. So if you're a consumer, you can call up the timeshare developer and say, John Smith, a made-up name, told me X, Y, and Z, and that was it's clearly false. It's come out that that's clearly false, and I'm upset about that. And the timeshare company will make an internal log, and they'll have it. They'll write all the details about it down. And then in the course of arbitration, if my consumer was defrauded by that same person, and we get that person's complaint history, that can be used in evidence in certain ways, and that tends to put weight on the scale in our favor at an arbitration hearing. But at the end of the day, really, the consumer's testimony is enough. I'm comfortable proceeding all the way to an arbitration solely on the consumer's testimony.
Now, do you feel that one reason why I've been very hesitant to suggest anyone go to arbitration, we had on episode 62 Jay Kumar, who's taken over I think over 100 cases for Wyndham, a mass arbitration that he's conducting. But I was concerned about the adverse ruling where on the East Coast, one family was ordered to pay the $50,000 loan and $60,000 in the resort's attorney's fees. Right. And they were represented by a good lawyer. That's one of three. The other two were even worse. And I know of two more, but that attorney was incompetent. I just saw a declaration, something filed where they're filing for bankruptcy, and he filed in court first, which you go straight to arbitration, right? You don't file anything in court first. But so two questions. Florida is a timeshare mecca. Right. And if you're paying, the developer is paying the arbitrator $400 to $900 an hour, who are they going to like? How do you avoid bias? We actually had a retired criminal investigator in California that was disputing a timeshare company, and he met the arbitrator from the resort in the airport lounge coming back from a golf trip. Sponsored by the resort. So right. A couple of questions in there. How to avoid having to pay 50. One of them was ordered to pay $79,000 in the resort's attorney's fees on a $5,000 dispute. And then does jurisdiction matter? Is Washington State or Oregon friendlier than Florida?
Sure. So those are both excellent questions, and it's something that I've contemplated quite a bit. And so first, to answer the first question, my strategy for avoiding an adverse attorney fee award, meaning an award against the consumer for the fees of the timeshare developer, there are a couple parts. First things first, you have to look at the contract and see if the contract says that a prevailing party is entitled to their attorney's fees. So I have seen contracts like this. It's actually pretty rare in consumer contracts that a timeshare developer will state explicitly in the contract that there's an attorney's fee provision that says, okay, you can bring a dispute and you can bring an arbitration, but if whoever wins is entitled to their attorney's fees. Now that's a double-edged sword, of course. We think we're going to win these cases, I don't take cases to an arbitration hearing unless I'm very confident that I'm going to win. But if there is an attorney's fee provision in the contract itself, that poses a danger that if you lose, you could be subject to their attorney's fees. I mean, there are ways that we could try to fight that, but it's a real meaningful risk in that case. But I have not seen very many contracts that have attorney fee shifting provisions in them. I think what is more common is reciprocal fee shifting provisions in causes of action. And by a cause of action, I mean, for example, a statute. In Washington state, it's the Timeshare Act and the Consumer Protection Act. In other states, they're called other things, but they're very similar. Many states have their own Timeshare Act. And some of those Timeshare Acts will say, if you bring this action and you lose, you could be subject to an adverse attorney fee ruling. So that means that essentially it's a prevailing party standard. So whoever wins could potentially get their attorney's fees paid. I'll go into that a little more in a second. But the way that I avoid that question entirely is I only use causes of action that have a unilateral fee shifting provision. So for example, the Consumer Protection Act in the state of Washington only shifts fees in favor of the consumer. If a consumer brings an action under the Consumer Protection Act and loses, there is no provision that states that the consumer could possibly be responsible for the attorney's fees of the timeshare developer or the company that they're bringing the claim against. It's not possible under the Consumer Protection Act under ordinary circumstances. So if you only use a cause of action that has a unilateral fee shifting provision, and again, I'm referencing Washington state law, but there are other laws I've seen from many different states where, there's one like the Timeshare Act, for example, might have a reciprocal fee shifting provision, meaning it could go both ways, and that's risky to the consumer. But then there's a different law that we can use. It's usually kind of similar to a Consumer Protection Act type law, where the fee shifting is unilateral and only can be awarded to the consumer if they win, and there is no risk of an adverse fee award if they lose under normal circumstances. So that is the way that I avoid even the possibility of an adverse attorney fee award. Now, that's not to say that it's completely impossible that we bring in arbitration and there ends up being an adverse fee award. There's in my view, if you take strategic action as I've described, first of all, you review the contract. Is there an attorney's fee shifting provision? If there is, you have to explain that to the consumer, and they have to be comfortable with taking that risk if there is. That's just, unfortunately, that's the fact of the matter. Usually there's not, fortunately. So then, we move on to the next step, which is, okay, which state are we in and which law is going to apply to this transaction? And so which laws can we invoke that only have a unilateral fee shifting provision that can only go in favor of the consumer? And those laws are out there. I have never run into a problem where I couldn't find a law that I could use that only had a unilateral fee shifting provision. And so you have to be strategic about the laws that you're choosing to use. And that basically, I don't want to say it completely closes the door on an adverse attorney fee award against the consumer, but it's pretty close. I'm highly confident if I'm strategic about this and we're very careful at the outset with the contract and the laws that we're choosing to invoke in trying to bring our claims, that we can almost completely eliminate the possibility of an adverse fee award. So then your second question is, how do you avoid bias? First of all, yes, the arbitrators are paid. They're paid highly. Their hourly rates are high. I have never had a situation where that made any difference. I have never detected any kind of bias for economic reasons. I think most arbitrators are basically completely neutral. If anything, I think, so first of all, let me just address, there is some bias. I've met a lot of attorneys in other states, some attorneys that are practicing in Nevada, some attorneys that are practicing in Florida, and they're trying to bring these disputes, and they're running into arbitrators who do not have a bias based on economic factors like who's paying the arbitration administrator, but the economy in these places like Nevada and Florida is so deeply intertwined with the travel and resort industry that you're going to be very, very, very unpopular if you start giving adverse rulings against the rainmakers. These timeshare developers are bringing in, a lot of
90 billion a year in Florida in tourist money.
So think about how that trickles down throughout the economy, all the way down to, the casinos, the cocktail waitresses, there's so much economically that transpires because of these resorts, that I do think, from what I've heard, I haven't actually experienced this because thankfully I'm in Washington State. And so the arbitrators have been kind of from my neck of the woods in my arbitrations. But I have heard from attorneys in Florida and Nevada that there is a bias towards the developer and it's harder to prevail. Fortunately for me, when I file these arbitrations, it seems to be the procedure of the arbitration administrators to select from a pool from which the claimant's attorney resides or where my office is located. And so all the arbitrators that I have had in my arbitrations have been totally unbiased, in my opinion, and totally reasonable. And I have not come into a situation where I felt like we were at an unfair disadvantage.
Well, and it's not just timeshare. I think it was 2019, there were like 17 attorney generals that tried to, they signed a letter to try to remove pre-dispute arbitration. So the consumer can opt out of the arbitration within usually 60 days of signing. And they say that that ability to opt out just gives it more teeth, that they can say to the judge or the arbitrator, well, they could have opted out, but nobody does. And so that's something. Now, the one question, I just want to make sure, because this is asked over and over and over again.
Sure.
And it's not, most people, they'll accept the fact that their credit score is going to drop up to 200 points if you default on a loan. But I've had one law firm call what they do attorney assisted strategic default, where you go ahead and default, but once it's charged off, it comes back. And if you don't stop making loan payments, you may as well not retain their law firm because they'll ignore you forever. Now, and then the mass arbitration, Jay Kumar told me that it was better to continue to make your loan payments, but some of these developers are really good at stringing things out as long as possible because they know that that's more of a burden on the consumer than their armies of law firms and in-house counsel.
Right. So I think you're asking what is my opinion about whether a consumer should continue to make payments. And so you're absolutely right. This is a question that I've asked in virtually every single consumer arbitration that I represent somebody in. They ask me that same question. Should I continue to make payments? And the answer depends on your personal circumstances. What I tell people is, if you care about a risk to your credit, if you care about your credit, then continue to make payments if you can. If it's not going to be disruptive to your life, if you have to choose between your timeshare mortgage and your residential, your mortgage for your home that you live in, then my suggestion would be to choose the more important thing, which is your home that you live in.
No, my question is there greater success of having a successful outcome in arbitration if you're making payments?
I don't think it makes a difference.
Okay, that's really important. Okay, now I have 10 questions. We've answered one of them, and we have another. We have yeah.
I have a question about my situation. As I say, I do have a loan of 8,000 on my credit card. I thought sometime we just signed the contract by a month or two in July. I thought about disputing the amount, the 8,000 on my credit card, because I was not expecting anything on that. I was not expecting to have 8,000 something to be paying on top of my $220 I support to be paying for the total amount of 17,000. So can I dispute that amount, or there are nothing I can do? And if I dispute that anything can be changed, or I don't know. I'm just lost and
And it's basically because of your lack of knowledge of how financing works, because she has a contract that says 17,000 down payment 8, but her real dispute is she wasn't aware a credit card with a 25%, 19 or 25% interest rate was being charged, opened or charged. Is that enough to dispute?
Right. So first of all, I don't think that it's just a lack of knowledge of how financing works. I think it's totally deceptive and unscrupulous on the part of the timeshare developer. This is something that I see very frequently in way more cases, probably a third of my cases, where the timeshare developer and their sales agents will actually open a line of credit in the consumer's name without telling them. And they might never tell them. They might just say, sometimes it's as bad as sometimes they open the line of credit, charge an amount, it could be 8,000, could be 10,000, could be 15,000 to that line of credit, never say anything to the consumer about it. And then they say, look, you're going to get this.
Happened.
Right. You're going to get this great deal. This is all you have to pay. Then they represent that, there's not this other part. They hide the part that's been charged to the credit card. And they say, look, you're getting this great deal. Normally, this is what it costs. Now it's only cost this for you. They sign the contract. 6 months later, they get a credit card statement, past due delinquent statement from the credit card company. And they think, what is this? I never opened a credit card. And then they reverse engineer and trace the steps back. And they figure out this sales agent must have open a line of credit in my name. So first of all, yes, absolutely. That's a reason to dispute the credit card. I would absolutely encourage you, Aku, to go to the credit card company and say, this is fraud. Shut it down. This is fraud. I did not authorize this charge. This needs to be reversed. And I'm not paying this. And Aku, I'd be happy to speak to you more, after the show about what steps you can take to try to do that.
Okay.
Fortunately, where there are, when it's a credit charge and not like a bank transfer or something not like a debit, but it's on a credit, it's usually easier to get the transaction reversed. And sometimes they can go back months and months and reverse something that happened a long time ago. And so that's definitely worth pursuing.
Mary was just charged because she bought in, it was like 4 months later, and they said it's usually 60 to 90 days. So even though it might have been 5 months or so, she can still dispute it?
Yeah, absolutely. Absolutely. I would dispute it if it was 5 years ago. There's no reason not to try.
Yeah, they said they just told her, sorry, you're too late.
Okay, well then, that's not satisfying to me. I would continue to try to pursue additional avenues, and they probably have their own dispute resolution situation in their credit contracts. It's usually an arbitration again.
Yes.
But I'm not just accepting their answer of, oh, too bad, you got defrauded and it was $17,000 and now you're just going to be stuck with it. That's not going to fly with me. We're gonna find a resolution to that, and it's not going to be that my client is out 17 grand.
Okay, great.
So
Now,
if
go
we
ahead.
dispute, is that affect any way our credit score or is?
Yeah, so it's I don't think so. I'm very careful about what I say about people's credit, because as far as I've been able to tell, honestly, in my professional practice and in my personal life, the credit bureaus seem to be mystifying, kind of amorphous entities that are basically beholden to no one and can do whatever they want. And so I don't know for sure, but I do not think there is. I don't think there's any way that disputing a charge as fraudulent would end up actually harming your credit. I don't think so.
Anyway, for now, I'm still paying because they put that down payment, the 8,000 on, and my monthly, my loan and my maintenance fee on the same credit card. So I'm
Right.
still making payment. The only thing I didn't start, I just do the first payment in September, the beginning of this month. And I didn't touch nothing. I didn't pay anything more than what I'm supposed to pay, which is $220. So I think if I dispute it now, it should probably, I don't know, it will not affect because I'm still making payment on the credit card anyway.
No, that doesn't matter. You still have a claim. We could pursue your claim for you. It doesn't matter that you already made one payment on it. They've backed you into a corner. This is This is very emblematic. Your situation, Aku, is very emblematic of the timeshare fraud industry. I mean, they back people into the corner. They're abusing vulnerable consumers. They're taking advantage of people, and there is no justification of that. And there's no they can't just claim that it's all good and well because you've made a payment now after they backed you into a corner and scared you into making a payment.
Okay. Wow. Well, I'd like to shift topics because this is something that has just bothered me so much because it involves all of our active duty service members that serve our country and have, and so, and I asked Attorney Mike Finn, and his answer to what I'm going to say is it was a very narrow ruling. Okay, and this is burning inside of me, so you don't know how grateful I am that you're here. So the first lawsuit was Blue Green versus I forget the plaintiff's name, but it was against Blue Green for violating the Military Lending Act. The judge said that you can't trace the damages to the Military Lending Act. Okay, so 6 months or however long later, Steins versus Westgate, and I attended the lower court. Judge Dalton ended the day by saying, when I check out of a timeshare, I can't leave my underwear and toothpaste, arguing that a timeshare loan is not a mortgage loan. And as it pertains to credit, one credit expert that was on our show said, you should dispute that it's not a mortgage. Okay, so Attorney Mike Finn said, if there's a mortgager and a mortgagee and the mortgager accepted the note, then sorry, it's a mortgage. But then you had the appellate court that upheld the decision that a timeshare loan is not a mortgage loan because the Military Lending Act exempts home mortgages, which means everybody in that class action, should they prevail, all of the contracts would be void from inception. And the Military Lending Act prohibits arbitration, which
Right.
is evidence enough for me. We talk about it being pro-developer, but there's been a lot written about arbitration as a whole being pro-industry and not favorable to the consumer. So Fannie Mae's website states that a timeshare loan is not a mortgage loan, even if it's reported as such. The NCUA, the National Credit Union Administration, says it's not a mortgage. So then in the Holiday Inn lawsuit, the judge did not cite the Westgate case, which to me made the Blue Green case a moot point. And so and then all the other developers are just saying, well, we don't agree with it. With that much, those prestigious bodies saying that it is a mortgage, how do you feel about that ruling?
So first of all, I'm not familiar with these rulings. The first thing that comes to mind is I don't know the jurisdictions of these courts. I don't know whether they're state or federal courts and out of which states or circuits that they're in. But I'm not surprised at all that there are legitimately, prestigious and prominent courts that are making the ruling that these are not mortgages. Okay, it's Florida.
Mm-hmm.
Okay, so I completely agree that they're not mortgages. And part of my strategy in litigating these cases, I'm developing and learning new things all the time. But I think actually that it's deceptive in and of itself for a timeshare developer to call their loans a mortgage, and not only call their loans a mortgage, which are nothing more than a usury. I think Aku said that her loan is 20%. A lot of these timeshare loans that I see are literally at the statutory maximum. Most states, I think probably all states, will promulgate legislation that says you can only charge up to X amount of percent per year. And the timeshare developers are almost always right at that extremely high amount. There's nothing about a timeshare loan that resembles a mortgage. And so I think the term mortgage is extremely deceptive. But even further than that, they also use terms like equity. Okay, so they're using the term equity to describe the amount of the quote unquote mortgage that you have undertaken for your timeshare. And as we know, these timeshares are not only are they economically worthless, you can go on eBay right now and look for any major developer's timeshare, and people are trying to give them away. They're for sale for $1 because that's the lowest amount you can put something for sale on for eBay. The mortgages on these timeshares that are on eBay are fully paid off. And sometimes I have even personally seen that the seller of the timeshare, which has a paid off mortgage, will offer like a $500 or $1,000 Visa gift card as a part of the purchase. So they're actually they're making an offer to pay you a $500 or $1,000 in a Visa gift card to take their timeshare, which has a fully paid off mortgage, which presumably means that it's complete with equity. Your equity is complete in the mortgage. There's nothing outstanding. There is no value. So equity indicates, or it has a connotation, obviously, of having some value. If you have equity in the home that you live in, that's like it's a nest egg. It's a savings. And the timeshare developers are using the term equity in a place where it is completely contrary to what actually is reality about the timeshares. And so I think many of the terms that they use, off the top of my head, mortgage, equity, closing costs. They like to say closing costs. They like to steal a lot of terms from traditional real estate nomenclature and impute them to the world of timeshare fraud to continue to give the appearance that these timeshare ownerships have some kind of economic value that resembles traditional real estate, which could not be further from the truth, as we know.
Well, in California, a New York law firm sued Marriott for saying closing costs for a product that's not real estate, and then Governor Scott legislated around it by removing the definition of beneficial interest, removing timeshare from it. So you can't fight City Hall. Now, your grandmother's timeshare, of which I have one, is let's say it's week 32, it's unit 58. So you check in, there's a deed. Okay.
Right.
So can you argue that that's real estate, but Diamond Resorts non-deeded right to use points? How can that possibly be considered a real estate? Oh, and by the way, I have a Florida real estate license.
Okay.
And in teaching the course, this threw me through the roof too. I asked the attorney that sued for the MLA, and I asked Mike Finn, I said, but I just took the real estate course, and they said that there are two types of real estates. There is the, your grandmother's fixed week that is real estate, but the right to use is a lease, which is not real estate. And they said, well, just because they teach that in real estate courses doesn't mean it's the law.
Yeah. Well, I think what you were taught was correct. I understand the argument that there are deeded timeshares. And while those deeds, in my view, are basically illusory, you have some kind of right to some kind of deed. It's a very convoluted and complicated transaction. And although you own some kind of deed in some kind of capacity, you really don't have the right to dispose of it as you please. You can't even sell it to another person without the timeshare developer's permission. In most cases, they will have the first right of refusal.
Yeah.
Obviously, you can't mortgage it. You can't put a second mortgage on it. You can't. It's not disposable or fungible, and cannot be used at your leisure. Like if you have a deed for like a car or for a house or something else. So I understand that there's a tenuous relationship in deeded timeshares to actual real estate. I still would argue, and I think it's a good argument, that it's extremely deceptive to use terms like equity and mortgage and closing costs in a situation like that, because at the end of the day, it's misleading to consumers. It's misleading to consumers. If a consumer who doesn't know anything about the timeshare industry hears that I'm taking on a mortgage and I'm building equity and I have closing costs, that is going to indicate to the consumer that they're buying something that resembles traditional real estate as it is commonly known, which of course is not the case. Now you move on to the outright, what I view is basically outright fraud, outright deception, and misleading way to phrase things, which is with a points-based timeshare where there is no deed attached. I can't think of a way that you could justify calling it real estate or using the terms closing cost, mortgage, equity. I think it's an outright falsehood. And it's actually a strategy that I am going to use moving forward. This is a landscape, the legal landscape, especially here in the Pacific Northwest, is basically barren and void of interpretations of timeshare statutes and consumer protection statutes that relate to Timeshare Act violations. And so we're basically charting new territory. What I'm doing in my law practice is charting new territory in a lot of ways, especially in the jurisdictions in which I'm licensed, which is Washington State and Oregon. In fact, in my last arbitration, we had alleged a violation of the Timeshare Act, which again is RCW 6436. And the arbitrator, who was a really well-respected, very good judge, retired King County Superior Court judge, said to me, they said Connor, and to the other attorney, they said Connor, and other attorney, I won't name him, but I want you to give me some information about this law. I'm not familiar with this law. So I went on LexisNexis, which is a legal database, one of the main big legal databases where you can search up laws and get case precedent, case history. And I typed in the specific statute that he was referencing under the Timeshare Act. And I believe it was 4 of the 6 results were authored by me. And the other two results were not relevant. And so that's very unusual. There's basically nothing interpreting these statutes. And so, as we move along here, I would love for some courts and rulings like you've described to set some precedent that, hey, this is misleading, because in my view, this is a glaring example of misleading the consumer. Just the simple fact of labeling these things, especially in a points-based timeshare, a mortgage, equity, closing costs, that is glaringly misleading and should not be allowed to stand.
Okay, now how TARDA was formed was I was referred to a lobbyist in Washington, D.C. And we had what I suggested. I said we should amend the timeshare. Let's take Washington State to go to them. And the biggest problem is that reading they always say you should have read the contract. And when you call these lawmakers, that's the first thing they say. You signed a contract. Reading the contract does not protect you. The rescission period does not protect you. If they sell you someone a brand new complaint, they sold me 83,000 points, which might be you could book 2 or 3 days, but they were promised a week for a family of 4, but they didn't have access to the booking site until after the state mandated rescission period had expired.
Right.
The other example is, and the culprits here are Vacation Village, Westgate, Wyndham, couple, Soleil Management, a recent one, where they say, and Megan was on our show. She's pregnant with her 3rd child. And this Wyndham sales agent told her, now don't worry about your husband, a Marine, being deployed to a combat zone. You can rent it out and it'll pay for itself. And we had Tom Gwynn on, where Wyndham's programs don't work. They're vacation share and extra holidays. So in great detail, they explain why they didn't work. Tom goes to another one and they say, no, yeah, they don't work well. Call this company, ask for this person. And he did, and it worked. He was able to offset 30% of his maintenance fees, then got a letter accusing him of commercial activity, drive him into default, because he has 1 million points that half of them were bought to rent. So can we go to a lawmaker in Washington State? And I'm so excited. The biggest news this week, breaking news, someone called their state representative's office and they referred them to TARDA.
Wow.
So can we go to a consumer-friendly lawmaker? I don't think all of them are consumer-friendly, and say, can we change the Timeshare Act that if they use the term equity, it must be disclosed, that this term should not be compared, is nothing compared to equity in a home, which is everybody's frame of reference. And if you promise the ability to rent, that it be disclosed, that this should not be counted on to make your offset your costs or make money. And one Westgate agent, and she got all her money back by holding up signs, and Lolo Explorer she just said something here that she talked about title fee, that's also, but anyway, I'm getting on too many topics at once. But would it be possible for us to go to a lawmaker in Washington State and ask them if they would consider amending the Timeshare Act?
Nothing would make me happier than to be able to amend the Timeshare Act. I've had that same thought. I haven't taken any action in that regard yet, but I would love to do that. I think it's ripe for updating. There are certain things, like you said, if they're going to say you can rent out your points, you're not going to rely on that. Well, they put that in the contract most of the time. But I think that there are protections that need to be in place. I think the penalties need to be stronger. Washington State actually has a pretty good Timeshare Act. The Timeshare Act here serves as a predicate violation of the Consumer Protection Act, which I have actually found to be fairly commonplace throughout the United States. Various states will have that kind of same structure where they have a Timeshare Act, and the Timeshare Act acts as a predicate violation of the Consumer Protection Act, and that's great. But like you said, there are still a lot of gray areas. And first of all, the one thing that I really think would need to be addressed by the legislature is that the rescission period for I think is in most states is 5 days.
Florida is 10 days, but what we want to lobby for is the rescission period begins when the purchaser has access to the booking site.
So I would go a step further than that. I think that the rescission period should last for as long as the arbitration, the opt-out period for the arbitration clause, which in my experience, has been 60 days. So
they'll never agree to that. Never.
Well, if you get a friendly legislature, I understand probably Florida might be an uphill battle, and maybe Nevada would be as well. But that's truly what would be a meaningful difference for consumers, because a lot of the people that I talk to and that consult with me and retain me as a client, retain me as their attorney, will figure out pretty quickly that they actually don't want this timeshare. They buy the timeshare, and where are you? Okay, so the rescission period is 10 days in Florida. I think it's 5 days other places, but let's say it's 5 or 10 days. Most timeshare transactions are done while you're on vacation. Yeah. So you're expected to figure out whether you want to rescind the contract during your vacation or the day that you get home. That's just not realistic. It's not going to happen. It really effectively does not protect consumers. And so if you made it 30 days or 60 days, that would give the consumer a legitimate, real opportunity to let the transaction sink in and maybe do a little bit of research and actually have a meaningful opportunity to decide whether this is something that they actually want.
Mm-hmm. Well, and Jeremy is going to be on our show next Monday. Jeremy, how to make the best use of your timeshare. And it's not his day job. He's an IT guy. But even though, people don't read all the contracts, one of the things that I also thought, the oral representation is buried in the fine print. Okay, of the contract. What's wrong with if they wanted me to know that I couldn't rely on anything a sales agent said? You get an appointment card, you get an email confirming your appointment. Why can't they just put at the bottom, do not rely on oral representations to make your purchase?
Right. Well, here's the thing. I think that the idea that you can't rely on oral representations in the course of a purchase is just ridiculous. It's totally contrary to common sense. If someone attends a timeshare sales presentation and a timeshare sales agent who sometimes, a lot of times, are licensed real estate agents in their state, sometimes they are actually licensed real estate agents, sometimes they're simply licensed timeshare agents, and they're telling you all these qualities and characteristics that the timeshare has. It's completely unfair and contrary to common sense, in my view, to just say you can't rely on anything this person said. Oral representations are not, don't have any effect here. Simply read the contract, and then they hand them a 50-page fine print contract with a 250-page public disclosure. It's not fair to the consumer to put them in that position. And sorry, go ahead.
But we have 5 minutes left. One thing Jeremy brought up with ARDA, not to be confused with the American Resort Development Association, a law, the state representative, Shauna Bullock, proposed a bill that would have allowed timeshare buyers 24 hours to consider their purchase before signing. It passed 100% in the House. In the Senate, the ARDA lobbyist got up and said, it's not the state's responsibility to protect people that don't bother to take the time to understand the product. They raise $5 million a year from people who do not know who they are. I've asked about 1,000 people, do you know who ARDA is? And they were fined in 2010 for not calling donations voluntary. So what do? When I go to pay my bill, it says pay your bill. To see that $7, which is opt out, I have to call them to take it, to take that out. So, but that doesn't mean, like, Martin Luther King didn't think that he was going to solve all the problems with civil rights, but he made a difference. And so as Jeremy said, you're going to get lobbied against. People don't read the contracts. That doesn't mean we can't attempt to try to put those disclosures in there. Now, this has been amazing. This is, Mary, you've been a little quieter. Do you have anything to say before we leave?
Before you leave? Not quite. I was just thinking, I wanted to ask Connor, should I focus on the Barclays credit card? Or I just wanted to tell you too that she did, she went to the back room and came back, and she told me that she had opened a credit card. I thought it was maybe like a Wyndham credit card. She didn't specify. Barclays at 25.99%.
Right.
And that's when I said, okay, maybe I can get a loan. I knew at the time I could get a reasonable loan at 8%. Or 7%, whatever.
Yeah, that's exactly what they told me. They told me when I called them to get a loan from another company and pay this one off so I can. That's how one of the agents told me when I called them about it.
Yeah, sorry, go ahead.
At that time, I did not know it was 25.99% because I would never, ever have a credit card with that. Right. The maximum would be like 14. Right. And but I did not know that until after I came back from Texas, and they took a while to send me all the paperwork. And then
okay, we have 1 minute left. Let's let Connor answer your question.
Okay.
Yeah, sure. So I think the question is, what can I do about this credit card? Basically, what I would suggest is the same thing that I suggested to Aku, which is dispute the credit card, do everything that you can directly with the credit institution. They're highly regulated, and when they receive reports of fraud, they have to take those seriously. If they don't, it's kind of like when you get into a dispute with a timeshare developer and they just ignore and stall and everything. Well, we have to bring the fight to them. So I'd be happy to talk to you about your particular situation. I'd be happy to talk with both of you, Aku and Mary, about your particular situations and what you might be able to do in furtherance of reversing those transactions. And if they don't do it voluntarily, doing it by force and protecting your rights, which are promulgated by law. And I'm confident that you are protected by law, given the circumstances that you've described. Now, the last thing that I want to say, Irene, again, I really appreciate you having me today. And I just want to say, to your point that, you said MLK didn't think that he was going to make the world a perfect place, but we can make a difference. I absolutely agree. I echo that sentiment. We're standing, there's a small network of people, including attorneys and non-attorneys, but we're trying to make a difference in this landscape of outright fraud and deception, and we're trying to help these consumers. And if we have to do that one consumer at a time, and if we have to take the fight to them day after day after day after day, that's exactly what I intend to do.
Well, thank you so much.
you.
And we've now I had 10 questions and you've answered 2 of them. So
We only need 8 more episodes.
let's put you on maybe once a month. I would love it. You know, we can do an Ask the Lawyer. I think our ratings will go through the roof. So thank you, Aku and Mary, for joining us today. We'll get Jeremy's question answered next week when he's on the show. So thank you all, and we hope to see you on. Mary's been on the show before, and so has Aku. So thank you all. Have a great rest of your
Thank
week.
Thank
you
you,
very much.
Irene.